So good morning, guys. So welcome back to my channel. It's an early morning while I'm recording this video. To avoid copyright claims on people playing songs at the background, and I'm forced to pull down this video. So today's case is an analysis of a landmark case that happened in Kenya, and the case was so locus classica, so major to an extent it went up to the Supreme Court. In 2021, the Supreme Court had released its ruling. What is this case, and why is this case so relevant when it comes to admission versus confession in Kenya? Now, the case concerns two parties, Abolfadi and Mafsrui versus the Republic. The case began in 2018. These two parties had come to Kenya with travel visas in order to look for business opportunities that they can invest in Kenya. And in the process of doing so, they booked a flight, a JKIA International Airport flight that took them to Kenya, and they were so lucky to have been booked a hotel at Mombasa by golfing agencies. So they checked into this hotel for free, and they decided that let us now go to Nairobi and via a local flight, and they boarded the flight to Nairobi. In Nairobi, they booked another hotel where they spent 3 days. And then they decided, you know what, let us go back to our country. We have noted down all what we wanted to know. And they were heading now to JKIA Airport when they were stopped by anti-terrorist police officers. And the anti-terrorist officers took them to the cell and told them, we are drafting for you a charge sheet on possession of an explosive, RTD. RTD, it was said by the police charge sheet that it is an explosive under Explosive Act in Kenya, Section 29. Now, the personnel, the parties, Abolfadi in this case, was convicted. One received a life imprisonment by the magistrate court. Remember, we are the magistrate court. And the other received 15 years imprisonment. And the matter was not yet over. They were so aggrieved by the decision to an extent, they went to the Court of Appeal and then later went to the Supreme Court. Now, let me show you the decision and the trial process that took place on those three courts. So, this was the trial process. Aggrieved by the magistrate court, they appealed to the High Court. And in the High Court, the judge set aside and substituted the life imprisonment with now 15 years imprisonment, which was to run concurrently with their sentences. Then, being dissatisfied with the decision of the High Court, the applicant still appealed to the Court of Appeal. And in the Court of Appeal, after hearing, the Court of Appeal allowed their appeal, quashed their conviction, and then set aside the sentence. Aggrieved, the state now sought leave to have the matter certified as being of general public importance. When a matter has been certified as being of general public importance, it has met the threshold to be taken to the Supreme Court. So this matter found itself in the Supreme Court. In the Supreme Court, the state wanted to know the difference between admission and confession. And as what you are seeing there, those were the grounds that the state brought in their submission. And the Supreme Court found that the Court of Appeal was correct in finding that the chain of circumstantial evidence had been broken, which would have led to an acquittal. However, they were dissenting opinions, and therefore the Supreme Court went ahead to set aside the decision of the Court of Appeal and upheld the decision of the High Court and that of the trial court, and ordered that the accused serve the remainder of their sentence, then be repatriated back to their country. So the main issue that I'm going to address today was whether despite the repeal of Section 31 of the Evidence Act, information given to the police by a suspect leading to discovery of material evidence, and such discovered evidence is admissible under the provisions of Section 111 of the Evidence Act. What is the difference, and what is the test to make sure that the information given by a suspect is not being taken down to be admissible before the courts of Kenya? What will the court say? Let us analyze the statements. I know you have grabbed your coffee and you are wondering, what is the difference, by the way, between an admission and a confession? Grab that coffee and listen to the following analysis. You are aware in Kenya that interrogation under police custody is a standard procedure recognized by the police standing orders and the judge's rules. Now, what is the rationale of taking that which has been said by a suspect, that the information that is going to give the police officer that he knows where the evidence is, and he wants the information not to be used against him in the court of law? What is that rationale? What will the judges say? Remember, at times the suspect may be under pressure and may either admit or make a confession before the police officers. Do you know when are these two separate terms recorded as different? Let us now look at what is an admission. An admission has been recorded under Section 17 to 24 of the Evidence Act. I'm going directly to what Section 17 says. It says that an admission is a statement, whether oral or documentary, which suggests any inference as to a fact in issue or relevant fact, and which is made by any of the persons and in the circumstances hereinafter mentioned. Black's Law Dictionary has also gone ahead to define an admission as any statement or assertion made by a party to a case and offered against that party, an acknowledgement that facts are true. Now, the distinction is not yet clear. Let us now jump into what will make this clarity be revealed. And the next will be what is circumstantial evidence. Circumstantial evidence has been defined as that which is not given by eyewitnesses' testimony. It's an indirect form of proof, permitting inferences from the circumstances surrounding disputed questions of facts. It is also said to be the evidence of some collateral fact from which the existence or non-existence of some fact in question may be inferred as a probable consequence. We have a landmark ruling case in Kenya, and it's called Kipkering Arap Koskei and another versus the Republic, a case that occurred in 1949, where it brought a major legal principle that articulates the circumstantial evidence well. The principle says that evidence must irresistibly point to the guilt of the accused persons in this case, to the exclusion of any other person, in that the evidence should be so straight that it cannot be another person. For instance, during a crime scene, there is evidence collection. DNA samples are taken, and the DNA has directly extinguished any other person from the circumstances surrounding that crime. That is a good example of circumstantial evidence. However, what is a confession? At times, a suspect may be compelled to say that he took part in the crime. What is the confession? And what is the difference now between admission and confession? Under Section 25 of the Evidence Act has defined a confession in the following terms. A confession comprises words or conduct, or a combination of words and conduct, from which, whether taken alone or in conjunction with other facts prove, an inference may reasonably be drawn that the person making it has committed an offense. Black's Law Dictionary has gone further to define confession as A criminal suspect oral or written acknowledgement of guilt, often including details about the crime. Therefore, a distinction has clearly emerged from those two definitions. As land authors William P. Richardson stated, an admission is an acknowledgement of fact from which the guilt may be inferred by the jury, while a confession is the express admission of guilt itself. I decided to list down, as outlined in the case of Al-Fadhi versus the Republic, the 6 key differences between a confession and an admission. Number 1, a confession is an untainted by any legal disqualification and may be acceptable as conclusive in itself of the matters confessed. An admission, however, pursuant to Section 24 of the Evidence Act, is not conclusive proof of the matters admitted, though it may operate as an estoppel. Point number 2 that I found relevant. A confession is a direct admission of guilt, while an admission amounts to inference about the liability of the person making the admission in the case. Number 3, a confession always goes against the person making it. An admission may at times be proved by or behalf of the person making the admission, as stated in Section 21 of the Evidence Act. Number 4, confessions are made in criminal cases, while admissions are both in criminal and civil cases. And number 5, confessions must be voluntary, but admissions need not be voluntary. At times you can be pressured by the police to admit to something. Number 6, confessions can be made by the accused. Admissions can be made by any person. That is the main difference between confession and admissions in Kenya. But we are not yet over. Let us now finish up the case. You are being confused of now what is the rationale of me bringing up the difference between admission and a confession. Relax. Let us now analyze what the court had to say on concerning the rationale of implementation of Section 25 of the Evidence Act. Let me take you back to history. Section 25A was first enacted in 2003 via the Criminal Law Amendment Act of number 5 of 2003. By then, the section was only reading that a confession or any admission of a fact tending to the proof of guilt made by an accused person is not admissible and shall not be proved as against such person unless it is made in court. Clearly, this amendment meant that confessions could only be admissible when made in court. But Section 25A came into place and repealed Sections 28, 30, and 31. However, Section 28 provided that a confession could be obtained from an accused person while in police custody only in the presence of a magistrate or a police officer of the rank of inspector and above. But a casual glance at the provisions of Section 29, which was not repealed up to date, reveals that the above mischief was not achieved. It retained a provision under which a confession made to a police officer of the rank of inspector and above to an administrative officer exercising managerial powers and acting in the capacity of a police officer is admissible. That means that if you make a confession before a police officer, it will be admitted in court. Is that just? Is that a good threshold? Thank you. Submit your comments. Likely, I'm pleased to hear from you.